All right, we have our sixth video. Let us bring up the PowerPoint. So our topic is offer and acceptance in traditional consumer contracting. This topic arises, remember, because we started with Stephen, we looked at reasonable expectations. Now, one of the topics that comes up in figuring out how Stephen's work is offer and acceptance will be a crucial topic for us when we turn to online contracting, and Stephen is a very good analogy. So let's see what offer and acceptance looks like in Stephen, and we'll try to apply the traditional doctrine to it. As we noted, that is difficult, and we'll see what progress we can make on those difficulties, or at least not us, what progress the law has made so far on those difficulties. And then we'll see if we can try to do better and improve on that as we go along and look at online contracting. So, and as you can see, our central case was going to be a software licensing case called ProCD versus Zeidenberg, quite a famous case. And so we'll take a look at it. But let's start with recalling Stephen. We described this last time. This is the presentation of the offer in Stephen, or at least this is the presentation that Stevens gets, right? When Stephen buys life insurance at the airport. And our question now is this presentation enough to count as an offer of buying life insurance? And our problem, as we remember from the last video, is that the difficulty lies in the manifestation requirement for offer and acceptance. Take a look, you see on the slide, right? We repeat the definition of offer and acceptance. Offer is a manifestation of a willingness to enter a bargain, so made as to just the offeree in thinking his or her assent will conclude the bargain. And we used the kindergarten bully as our standard example, right? No beatings in exchange for your lunch, that's the manifestation. And then the way it was made, you knew it even at age 5, you were justified in thinking your assent would conclude the bargain. The problem in Stephen is the manifestation. Where is the manifestation of a willingness to enter a bargain? We don't have anything like the full terms presented here. Right, the full terms are contained in the full contract, which Mr. Stevens barely sees, right? It's not presented on the vending machine, and the instructions are sign, put it in the envelope, mail it to your beneficiary before you get on the flight. And everybody knows there's no time to sit down and read the contract, then not by ordinary airport behavior at that time. This is long before all the security was in. People got to the airport, maybe if they were early, half an hour early, walked down, got on their flight. So Mr. Stevens not going to have time to sit down, read and understand a long, complicated contract. And that's not the idea. So where is the manifestation? Where is the equivalent of no beatings in exchange for your lunch? And that creates problems for acceptance too, because if the bargain is not, if you're not told the bargain, you don't have anything to accept, do you? So those are our puzzles, and we'll look for an answer. Before we start, always good to ask, well, what kind of an answer do we want? What would count as a good answer? And we want an answer that explains how in consumer contracting we have informed consent, right? We want the equivalent of no beatings in exchange for your lunch, or the equivalent, how we want the kind of information, that kind of information, or the information in the ads from Lefkowitz, right? We've got these clothes to sell, here are our prices. And of course, we want to ensure free consent. In the Lefkowitz kind of case, manifestation given, the no beatings in exchange for your lunch, the bully, right? In those kinds of, everything's out in the open contracts. We do have protections. We covered them earlier, right? We got the doctrine of inconscionability to ensure free consent, and also the rules on exculpatory indemnity and waiver clauses say, gee, if there's too much unequal bargaining power, then we're not going to enforce those clauses. So in the think back to Lefkowitz. Yeah, Lefkowitz, we got free and informed consent. The bully too. How do we have that in cases like Stephen? The same question will arise for online contracting with all those contracts behind the hyperlink. So let's start on ProCD versus Zeidenberg, 1996 case. So 1996, right? This is before the internet really takes off and before online contracting became a concern of courts, commentators, and consumers. So ProCD, let's get the facts out because we'll need them. Right? ProCD sold a CD, right, called Select Phone that contained every telephone number and address in every telephone directory in the United States. So remember this, so this is before the internet. Businesses are very interested in knowing how to contact consumers by mail and phone in order to send them advertising. Well, how do they find out what the names, phone numbers, and addresses of those consumers are? Yeah, telephone directories were one way, right? The paper-bound thick books with names, addresses, and telephone numbers. So Selectaphone decided to put all that information on a CD, and it sold it to businesses for $5,000. Well, we'll talk about what's going on there in just a little bit. But the case arises because they also wish to sell the same product to consumers. Now, consumers aren't going to pay thousands of dollars for a CD of names and addresses of people in the United States. So their solution was price discrimination by contract. That price discrimination is one price for one group and another price for another group, right? In this case, high price for businesses, low prices for consumers. Very common practice. When I was putting these slides together, the first time in 2014, I had just gotten this registration request for the major privacy conference. PLSC is Privacy Law Scholars Conference. Once a year, it's the big worldwide privacy conference. And they discriminate in prices, right? They just charge $400 for academics and $950 for practicing lawyers. And the idea that practicing lawyers have more money than academics, right? Two prices, same product. That's price discrimination. Same thing in ProCD, two prices, same product. So how did they do it? By contract in this way. How did they do it? How do they prevent a business from going in and buying the consumer product, right? This 1996, software was typically sold in stores, not online. And software came in boxes, so you could just walk into the store, pick up the box, walk away, pay for it, walk away with the software. So if they're going to sell the consumer product in those stores, how do they prevent businesses from walking in, buying the consumer product for $150 it was at the time, instead of $5,000, walking away? By contract, right? The contract said that you agreed not to use the consumer product for commercial purposes. And it gave you an 800, and I said, but if you do want to use it for commercial purposes, call this 800 number. So that was the plan. So those are the background of the case. It's worth spending a little time on the business model that ProCD had, because it illustrates typical features of technological innovations, and it gives us a broader background for the case and a further explanation of what was going on with the two prices, one for businesses and one for consumers. So let's spend a little time doing that. So at the 1996, right, mid-90s, right, the marketing companies, traditional marketing companies, sold hard copy list of names, addresses, and telephone numbers of people to businesses, and they charged a lot more for that than $5,000. ProCD looked at that and said, well, there's a much better way to distribute that information. Let's put it all on a CD then it's updatable, easily searchable, and we can deliver that and make money for charging around $5,000, much less than those companies, those traditional companies are marketing for an actually better product. And so we'll do a lot of business, and they did. Right, that was their idea, and they knew since the companies are paying more than $5,000 for the same information, they knew that $5,000 would be a good price, and then they wanted to. But if they want to make a little more on consumers won't pay that because they don't have the same interest as business, and they don't have the same history of having paid a lot more for the information. So that's what leads to the price discrimination. Just a little more background on the business model, just for our general knowledge, right? ProCDs, the Selectaphone program was quite expensive to produce, very cheap to reproduce, very typical of this kind of intellectual property, technological innovation. Right? It cost them $10 million to get the information onto a CD. What they did was collected every telephone book in the United States, shipped them all to China, where typists were particularly cheap in 1996, had it all typed into a database and copied the database to ProCD. So they've got their $10 million investment, which they're hoping to recover quickly from the $5,000 sales to businesses. They had a business problem that finally defeated their business plan, right? The marginal cost of producing a CD, what the economists call the marginal cost, the cost of producing one more, how much does it, once you're all set up, how much does it cost to produce one more Selectaphone CD? Very little, right? Just the cost of making another copy. So you got low, that's a really low cost once you get started. Your big costs are all the startup costs. And so the main barrier to competitors coming in to compete with ProCD is the $10 million startup cost. But many other companies did make that investment. Of course they did. You look and say, wow, you're getting $5,000 a CD for a CD. Once you've got it all set up, cost you next to nothing to produce. That's a good business. Think I'll go into that business too. And they did. They got every telephone book in the United States, shipped them to China, had them typed into a database and copied into a CD. So Selectaphone had competitors. And the price fell, right? The price fell. So if I'm a competitor for ProCD, I offer my product for less than $5,000. So people will buy from me, not from them. What is ProCD going to do? It could maintain its price and lose sales, or it could offer its CD for less than I'm offering mine, which is what they did. So what am I going to do? I'm going to offer for less than they do. And by this time, there's not just me around, there are other competitors in the field, right, competing with ProCD and me, and we're all dropping our prices as the others drop our prices. And that process will continue, in theory, right down to where you finally hit the bottom at the cost of producing a CD. The price just drops, right? And competition, and that's what happened to ProCD eventually. But it was a great idea at the beginning that just this problem they couldn't solve. So that's the background. But in 1996, ProCD is going strong, and the case arises because Zeidenberg buys the consumer package and ignores the stuff about you can't use it for commercial purposes. Now, Zeidenberg was a graduate student in computer science at the University of Wisconsin, quite good university. And there are two stories about Zeidenberg, and we don't know which one is true, right? One story is he looks at the CD and thinks, they're doing this on a CD, right? Why not just upload the information to a website, password protect the website, and charge for access to the website. And my cost of distributing the information will be much less than ProCD's. And so I can just charge a little bit for accessing the website, which is exactly what Zeidenberg did. Now, Zeidenberg claims he was deeply puzzled by the litigation and never did understand why he lost. That could be true. Zeidenberg can be a computer science student with very little understanding of business and just a desire to distribute information, right, in an efficient way. That would be very typical of the late 90s, early 2000s. The other story is he knew what he was doing, and he intended to make money by exploiting the commercial product, by buying the consumer product and avoiding the big cost and selling it and selling access on the web. In any case, right, whatever his reasons, ProCD objected, right, and they sue. ProCD sues him, saying he violated the license, the contract in the box. This is a software license, and in that context, it's typical to use the word license. It's a contract. So Zeidenberg says, well, what Zeidenberg's claim is, what contract, right? The contract in the box is not a manifestation. The only thing manifest are the terms on the outside of the box. Here's the box, right? That's to get a picture of his argument. Take a look at the box. This is a box from 2001. I couldn't find a 1996 picture, but same box, right? This is the box, and it's all shrink wrapped. It's all wrapped in that tight plastic wrap around it. And the information on the outside is mostly marketing information. It does say subject to terms inside, right? Here's what was on the outside of the box. Besides the marketing information, gee, this is a great product, buy it, and the typical, you need a computer of this much power. It said, and quoting from the court, every box containing its consumer products declares that the software comes with restrictions stated in an enclosed license inside of the box. Too long to print on the outside of the box, right? And here is Zeidenberg's argument, right? Zeidenberg says, well, look, an offer is a manifestation of a willingness to enter a bargain. And of course, this is the critical issue. And so made as to justify the offeree in thinking his assent will conclude the bargain. What was manifest? Zeidenberg's answer, only the terms on the outside of the box. And there's nothing on the outside of the box that says you can't use it for commercial purposes. That looks like a pretty good argument, right? Not a bad argument. The court rejects Zeidenberg's claim. By the way, the judge in this case is a famous judge, Judge Easterbrook, sits on the 7th Federal Circuit in Chicago. So you can actually go see Judge Easterbrook when you come to Chicago, which I very much hope you do. So the court rejects the argument. The argument looks good. It's the same concern we raised about Stephen. And Judge Easterbrook says, no, this is not correct. So, and my own view, I think Easterbrook is correct. The court is correct in rejecting Zeidenberg's claim. That is not how we treat offer and acceptance in consumer contracting in cases like ProCD and Stephen. But now the question is, the puzzle is why, right? Why, what justifies our doing it differently? And Zeidenberg's first argument is just an argument from practice. Zeidenberg's first argument, Easterbrook's first argument, the court's first argument, doesn't answer, well, why do we do it this way? But it notes that we do, in fact, do it this way. Transactions in which the exchange of money precedes the communication of detailed terms are common, right? Meaning down here. And one of Zeidenberg's examples, one of the court's examples, is the purchase of insurance. It's very typical to purchase insurance in the way the court describes. And the simplest example, you buy a car, at least in the United States, I buy a new car. let my insurance company know I bought a new car. They say, fine, you're covered. Right? I bought a new car, the X, Y, and Z description. Fine. I'm at that point, I'm covered. The contract is formed. And then some days later, they send the contract, right, with all the explicit provisions and details about exactly what I'm covered for and what I'm not covered for. And we want it that way, right? The court's point is, look, we do it that way, and it's incredibly convenient. I buy a car, it's not even legal in the United States for me to drive it without insurance. So I don't want to sit around and wait for the insurance contract to arrive and then for me to say I accept, a week or 2 weeks later. So I want to drive it right away, and we do it this way. Quite convenient. Airline tickets, another of the court's examples. Airline tickets, purchase of an airline ticket. And before they all went online and electronic, the contract was printed on the back of the ticket. The basics of the contract were printed on the back of the ticket. So you go out and purchase your ticket from a travel agent who printed it out right then and there for you and handed it to you, or you purchased it. Over the phone from the airline, and they sent it to you. Okay, and you didn't see the contract till after purchase, just like Stephen, just like ProCD versus Zeidenberg. Nobody thought that this was not a contract. The court's point is, look, if you think about it, we do pay, get, then see the contract all the time. It's the Easterbrook's third example as being concert tickets, theater tickets. If I'm going to go to a concert, I pay my money, I reserve my ticket, and then a little before the performance, I go pick it up. It's only at that time that I have any chance to see the contract. And of course, none of us read them anyway. So Easterbrook's first argument, the court's first argument, is that, let's look at reality. We do the purchase, then see the contract all the time. For the last 100 years, in fact, we've done that. It makes really good sense. It's incredibly convenient. We want it this way. If we've been doing this for 100 years and there haven't been any serious problems and nobody's really complained, then it's got to be all right, right? This is the way we want to do it. So the first argument is, like I say, just there, that we do it this way with the appeal. If we've done it for 100 years and it's worked, it's got to be okay, right? So, but how does it fit with our doctrine, and how does it meet our conditions on an explanation of offer and acceptance we said earlier? Does it show we have informed consent and free consent? Let's see if the court gives us an answer to that in its second explanation of why it's perfectly okay to form contracts in the way that Zeidenberg did. Pay first, get terms later. And the court appeals to the Uniform Commercial Code, which, remember, is the law on sale of goods in the United States. I mean, as we call it, it's the model law that all the states have adopted for sale on goods. And under UCC 2-204, which the court quotes, it says, look, even in the statute that governs sale of goods, we are very liberal about what counts as offer and acceptance. That a contract for sale of goods may be made in any manner sufficient to show agreement. Right? So anything you do that is sufficient to show that, well, gee, we got ourselves into a contract, that will do. You don't have to have offer first. You don't have to have terms first, then acceptance of the terms. You don't have to do it in the way the bully did, or that was done by the store in Lefkowitz. You don't have to hear my terms now you say yes or no. You can do it in the Zeidenberg Pro CD way, the insurance way, the airline way, the concert way. Pay first, get the stuff later, then read the terms. And we recognize that even in the statute that governs sale of goods, anything that shows you got a contract. That just okay, but that's the end of, that's where the court leaves it. Right, but we can add a little bit to the court's argument to make it, give it a little more substance, right? Just ask yourself, well, what is a manner sufficient to show agreement? Let's put a little A in there, okay? What is a manner sufficient to show agreement? And there's general agreement in the courts on that. The general rule, a manner sufficient to show agreement, is one that meets this condition. A reasonable person would be on constructive notice that he or she is being invited to enter a contractual relationship. Constructive notice, as you probably no doubt know, is just the term for actual notice, or a reasonable person should have been on notice, right? Constructive notice has two branches. Well, you really had it, or a reasonable person would have had it, right? So that fits. So if we do something, so the idea is, gee, if you do something where, well, any person doing that would realize they're being invited to enter a contractual relationship, then you're acting in a manner sufficient to show agreement if you enter the relationship. That fits the insurance example. Gee, I'm calling my insurance agent because I want to enter a contractual relationship. Insurance for my new car. Right? Not just that a reasonable person should know. I do know. Right? But anybody that doesn't know really should. I buy a concert ticket, same day. Look, if you're buying a ticket to go to the Michael Jackson show or the O show in Las Vegas, and you're paying money, you're entering a contract. You surely should know that. And same with the airline. So also the view of the second restatement of contracts. Okay, we're running out. Let me fix. I'm running out of battery because I forgot to plug the computer in. Let's make sure I don't shut down. There we go. Sorry about that. In the middle of that'll prevent the thing shutting down in the middle of the video. Okay, also the view of the second restatement. Which gives a good characterization of consumer standard form contracting. The second restatement intends this as a general characterization of the way we did consumer contracting, say, before all our online activity, and this still fits a good deal of our online activity too. They gave four features. Businesses do not expect consumers to understand or even read standard terms. We've emphasized that. Consumers don't ordinarily understand or even read the terms. Also understand. They trust to the good faith of the party using the form. And that is another way of saying they trust that the business, the party using the form, business will respect their reasonable expectations about terms. talk of good faith in consumer contracting comes down to just what it came down to in Stevens, trusting that the business will respect consumers' reasonable expectations. So we saw that in Stevens, and then they add 4, which is the one that is particularly relevant to us here. But they, the consumers, understand they're assenting to terms not read or understood, subject to such limitations as the law may impose. This is, they understand they're entering a contractual relationship. So both the Uniform Commercial Code law and sale of goods and the restatement, the summary of the common law, recognize the same thing. There's an offer. We'll say, basically, there's an offer if a reasonable person would be on notice, actual or constructive, that he or she is being invited to enter a contractual relationship. So that's as much as Pro-CD versus Zeidenberg gives us. Let's go back to what we said we wanted. Do we get it? Right? What we want, or ultimately what we want out of an explanation. It should explain how offer and acceptance ensures informed consent. And I don't think we've done that, right? We still have the problem that people don't read the terms. Yes, our practice over the last 100 years has been unquestionably to allow payment, purchase, taking away the good, then seeing the contract, purchase, then seeing even the contract about a service, even beyond a good. That has unquestionably been our practice. And we can, as the UCC and the restatement note, I mean, that they characterize accurately what we've been doing. But how does it ensure informed consent? We still have that problem. And how does it ensure free consent, right? If people don't read, how's their choice meaningfully guided by information about the terms? We discussed that problem when we discussed unconscionability in Henningsen. So we still have hanging over us the problem of understanding how our unquestioned practice for the last 100 years actually fits with what we want out of a picture of offer and acceptance. And this puzzle stays with us. This puzzle stays with us throughout online contracting. I will suggest a solution to this puzzle in a couple of videos from now, 2-3 videos from now. Just briefly, it's one of my areas of research, so that we have some idea of what a solution might look like. But our main goal here is to understand the activities and puzzles of online contracting by comparison to offline contracting, and we're well on our way to doing that. We have a few more issues about offline contracting, and we'll have our background comparison set up to turn to online contracting. And that completes this video. I will see you in the next video.